Are we ready? Is everyone on?
Yes, this is Andrew Holder. I can hear you. I'm
Mr.
ready
Holder,
whenever
I
everybody
cannot
else
hear
is.
you.
What about now?
No. Oh, wait a minute.
Mr. Holder, I can hear you.
Oh, okay. That's good.
Okay,
Can you hear me, Diane?
I can hear you.
Okay.
Are we ready?
Mr. Holder, I can hear you.
Oh, okay. That's good.
Okay.
Can you hear me?
I can hear you.
I think we lost plaintiff's counsel, unless I'm mistaken.
This is terrible echo.
I think we lost plaintiff's counsel, unless I'm mistaken.
This is terrible echo.
I think we lost plaintiff's counsel, unless I'm mistaken.
This is terrible echo.
Good morning.
Good morning, Your
Judge.
Honor. Sorry about that. I think I got bumped off of Zoom. I got
That's all right. We're all set, and we are live
back on as
streaming
quickly as
on
I
YouTube
possibly
as
could.
well.
Sorry about that.
That's right. We are live streaming on YouTube for purposes of access to the courts. Let me shut my back door here real quick. I'll be right back.
Very good, Your Honor. And I think my co-counsel was supposed to be on as well. I don't see him here yet, but he should be joining us shortly.
Okay, just for the record, and obviously when your co-counsel gets here, he can join in. This is 21CV4112, MCC versus Board of County Commissioners. And for purposes of appearances, can I get appearances now? And then, of course, your partner can join in when he gets here.
Very good, Your Honor. May it please the court, Ryan Kriegshauser, appearing on behalf of petitioner MMC, along with co-counsel Joshua Nye.
Okay, it looks like Mr. Nye is joining now. Go ahead, Mr. Holder.
Your Honor, Andrew Holder on behalf of the Johnson County Board of County Commissioners.
All right. Mr. Nye, you're on board? I see Mr. Nye.
Good morning.
You hear me?
Yes, I can now. Thank you, Judge.
Okay, great. And I'll show Mr. Josh Nye is appearing for plaintiffs as well. All right, this is a status conference. Council, we're all at the intersection of some interesting cases right now. We obviously have my case is on appeal. I think the school district's brief was due to be filed yesterday in the Butler case. You guys specifically mentioned that case in your petition because of my previous rulings about SB 40, at least as it relates to school districts in that case. And I just learned this morning, another case has been filed by 20 plaintiffs in another case against the Board of County Commissioners. I'm assuming all council is probably apprised of that as well. So the first question I think we need to address, and plaintiffs counsel mentions this in their petition, is the waiver of the supposed SB 40 statutory timeframes, 7 days to have a hearing, or basically 72 hours to have a hearing, 7 days to make a decision, et cetera. I don't know if that's jurisdictional. I've already held that's unconstitutional. But for purposes of this case, and is it you, Mr. Kriegshauser, that's going to be addressing this issue?
I sure can, Your Honor. I think my co-counsel dropped off, like I said earlier. I got kicked off of Zoom. And so I think either of us are prepared to handle that. And
Yeah,
Your
well,
Honor,
I guess what I'm wondering is, there's case law out there about whether these kinds of deadlines are statute or jurisdictional. Can they be waived? In other words, can you cherry pick certain aspects of a case? But I think the practical reflections of what's going on right now I'm assuming expedited means expedited, and that the Supreme Court will rule on this fairly quickly. If the Supreme Court fails to actually address the merits of the case because the Attorney General has raised the mootness issue, the issue is clearly not going to go away. Obviously, you folks are here. You agree it's not a moot issue, and likewise, the lawsuit that just got filed yesterday evening is going to bring that issue to the fore. So I suspect that all counsel arguing that case are going to be painfully aware of the fact that this stuff isn't going away, and it's coming up. It's in various iterations.
Yes, Your Honor.
The pandemic's not going away, and all the mitigation efforts for that, whether you are for them or against them, it's not going away. So thus we have these legal issues. So what I'm wondering is if maybe we all agree at this point that we'll have time to address whatever's necessary for the legal issues and any factual issues, and set up some kind of deadlines to do that. And that's just my thought. So I'll let plaintiff's counsel address that, and then Mr. Holder, you can kind of weigh in as well.
Very good, Your Honor. I can address that. I'm not sure if my partner's back on, but I did see that a motion to dismiss was sent to us from defendant's counsel. I haven't seen it come through the docket yet, but I believe it has been filed, and we are we have a response drafted to that motion to dismiss that we could get on file here shortly, even as early.
I think you froze up.
Just depending on what the court wants the
Stop,
timeline
stop,
for
stop.
the deadlines under SB 40.
Stop. I did not get that. You locked up. Your Zoom froze up. You said even as early as what?
Even as early as later today. If just depending on what the court's timeline, they want what the court wants it to be. But one of the issues raised in that motion to dismiss was, of course, the timelines in SB 40. One of the things that we briefed out or are briefing out in that is the Ambrosio factors, the 4-factor test that the Supreme Court set out to determine whether a deadline is mandatory or directory. And our analysis of those 4 factors, and again, we'll be briefing this fully for the court's review, is that the 72-hour deadline is really directory. There's no consequence if the court doesn't meet the 72-hour timeline. And that 72-hour hearing is what starts the clock ticking for that 7-day timeline that you expressed frustration within your order, Judge. But we don't believe that 7-day
waiting for the court reporter to go, stop.
Right.
All
We
right.
don't believe that 72-hour what?
Deadline is mandatory. It's directory in nature under the Ambrosio factors. However, the 7-day deadline is mandatory because there's a consequence if you do not meet that, as you pointed out in your order, Judge, that the petitioner wins if the court doesn't issue an order within that 7-day timeline. And so our feeling was that the 72-hour hearing can be waived by the petitioner under the Ambrosio test. And that's what we attempted to do in the petition, to not put the court under such a heavy timeline as dictated by SB 40. So we are open to setting timelines that the court can meet and we can meet and get this thing done expeditiously, but not at the breakneck speed that SB 40 contemplates, Your Honor.
Okay, and of course, I've not seen any of these motions. If it was filed, and I'm sure it was filed late, and I don't know if you filed your lawsuit on the cusp of the 3-day weekend. So, and that was done fairly late. You served Charlotte O'Hara. I don't know if she was a willing recipient of your summons, but the fact of the matter is nobody could humanly have a chance to respond within 72 hours the way you filed it. So that's number one. And we also have a local rule that requires verified petitions, et cetera. I don't know if you think that you don't have to comply with that, but I haven't seen that. My concern is if the county has filed a motion, obviously I'll have to see that. I would suggest, just to be on the safe side, gentlemen, that you send to Chambers your briefing. I can pull it off. So what happens is when you file something late or in off hours, it takes a while for the clerk's office to load it into the ROA. And right now, the last entry I have is the status conference reference to the YouTube address for this proceeding. So my thought is I need to see those briefs, decide whether this is something that has some emergent nature to it. So, Mr. Holder, you've been sitting there patiently. You want to weigh in on this?
Sure, Your Honor. In terms of my briefing, that's certainly something I don't know what my understanding and impression is that it was filed. I don't know. It's probably because it was filed after 5 that you don't have it. I'm happy to serve a copy on Chambers. At this point, it sounds like plaintiff's counsel has got a response. I would say I don't think there's anything in terms of that briefing that has to get taken up right here and right now. In terms of the deadlines under Senate Bill 40, I don't think I'm in disagreement with plaintiff's counsel's analysis. What I certainly think there are constitutional problems with the 7-day decision deadline, and those are outlined in my briefing. What I didn't want to have happen today is to have myself set up for an argument where I say I think those deadlines are unconstitutional, but I can't. I'm picking and choosing which deadlines to enforce and not enforce. I do agree with the analysis that I think the 72-hour deadline is not mandatory if we're all in agreement that deadline and not both deadlines, that the 72-hour hearing deadline can be pushed back. I certainly don't have any qualms with us setting a reasonable schedule in light of all the other intricacies going on with Senate Bill 40 at the moment. So I think we're in agreement about that.
Okay. What about now? What is different about this case, at least obviously, or the defendant is the defendant. But what is also different about this case is the fact that, before with the Butler case, we had a direct case that related to Section 1, which the Attorney General has argued, along with Section 2, which is community colleges, has expired because the emergency expired on June 15th. And of course, that really is, for court gurus, that's an issue of whether it's moot, whether it can reoccur again. Obviously, we think this is an issue that's going to come up over and over again till the Supreme Court weighs in. So if the Supreme Court evades that issue for some reason, this case, the other case I'm referencing, probably the one in Morris County that you guys filed, somebody's going to come up with something that's going to say, we think this issue needs to be decided. In any event, what's different about this case also is that school districts acting on pursuant to their own authority under the Constitution can regulate and manage their own school districts. And so if they decided we want this mask mandate or we want to take mitigation measures, that would then trigger something else. What we have here is the county basically acting as the county health board, directing all the schools that this is a health mandate, et cetera. And so now we have the intersection of the county's authority as sitting as a board of health, directing school boards. One of my concern is, obviously you've filed this as a pseudonym case with MMC. And of course, the other case that was filed, which for the record, I think is 21CV4112. And that case, all the parents are named. They have pseudonyms for the kids. So I'm not sure the parents have a significant privacy interest, but that person's going to have to be identified. And how we do that's obviously up to me because I have discretion to decide about that. But you mentioned in your lawsuit, Mr. Kriegshauser, that no other lawsuit had been filed, of course, against the county, but is your client also you're nodding no, I was going to ask you, directly if your client was also a party in the Baker case. And that case is on stay because of a motion that was filed by Mr. Baker to have me recused from that case. So we've got a lot of balls we're juggling right now. So I think what my concern is, if perchance there was any relief to be given to your client, the question then becomes whether the school board's independent authority to do what they think they can do. You know, that they have home rule powers. The county has home rule powers. One of the issues in the other case that recently got filed is whether the county can direct the school districts to do what the school districts may or may not want to do. So we got a bowl full of legal issues here, and you guys are young enough probably to live through the rest of the appellate life of these cases. So my thought is we need to really kind of outline what we're doing here. And this is why I think the 7-day deadline is kind of ridiculous, because there's no way we're going to be able to address all this stuff in that kind of time frame without some really hitting the books and finding out whether there are even any factual issues that necessitate requiring some decision. So you've teed up the motion to dismiss, Mr. Holder, is that correct?
That's correct, Your Honor.
Okay. And Mr. Kriegshauser, you said you've got a draft of a response ready to go?
Yeah, yes, Your Honor. It still needs a little more work, but we can have that on file here relatively shortly, just depending on what you want the timeline to be, sir.
Okay, well, can we all agree then if a decision, quote unquote, is going to be made, since this is not a case where there was sort of some underlying request by the plaintiffs to the county commission, you're just flat out saying this order affects us and we think it's improper for that reason. Is that fair?
Yes, Your Honor. I mean, we are basically saying that the 295-day length of the order is not narrowly tailored, and we'd ask that the order be in shorter periods and just subject to periodic review. We suggested every 30 days, just to allow. One of the problems and one of the reasons why this was filed before the holiday weekend is there's that 30-day period in which you have to file an SB 40 hearing.
Right.
Well, that was going to run, and the problem with the 295-day order is that if we did not get this placeholder petition on file, and then the Supreme Court came back and said, look, you can have these hearings in some way, well, then we're out of luck if we waited for the Supreme Court to rule. And so we had to get this on file, and I apologize, it was before the weekend, and we tried to make it clear to the court that we were not trying to put you under the gun, if you will. And so that is one factor, but we'd also argue that, to your point, the county level order is really superfluous because the school boards are altering it. They're doing what is they feel appropriate is for their schools. Spring Hill is taking a different direction than Olathe. And so there's really no point, legally speaking, from our view, for the Johnson County order. And so the school board.
That brings up two issues, and I'm sorry for interrupting you, but is the school board a necessary party to this case?
I would, well, I'd like to.
I mean, you're alleging that your middle schooler is being discriminated against by the school district. I mean, that's the county just simply passed a mitigation effort to say, as a matter of health, we expect K-6, or if there are folks in those buildings in the K-6, they need to be masked. They say nothing about discrimination or anything like that. I think they've kind of left it up to the school district. So if your client has a concern in that regard, there's already an existing Blue Valley lawsuit right now in this division. I'm wondering if that's the critical issue here. And secondly, if your contention is we just think that the county Board of County Health needs to take smaller bites at this in terms of 30-day increments, that's basically a decision the County Board of Health makes based on all the recommendations they've received. And I'm not sure the narrowly interpreted applies in that kind of instance. And then I guess the other thing maybe you guys need to brief, if you haven't done so, is what provision of SB 40 are you using as a basis for this lawsuit, Mr. Krieghauser?
Section 12 is what this lawsuit's under. And that
So you don't
does
think
come-
Section 8 applies?
No, we had contemplated that this came under Section 12.
Okay. Now, did you actually view the county commissions, and I keep saying county commission, but they're basically one and the same as the county health board they set in Bonk. Did you actually watch that proceeding?
I did, yes, Your Honor.
Okay. And did you know that Mr. Lee Master was the county health authority that was making the recommendation to the health board?
And we do get into this in our briefing, but Dr. LeMaster made a presentation that said it was a Johnson County order proposal. And he said multiple times that he was proposing it to the county, which makes Section 12 apply. And the assistant county manager said that both Dr. LeMaster and Areola, that this was their recommendation. It's like the first thing he started off with. And so
Okay.
it's pretty clear that this did come from LeMaster. And his PowerPoint said it was his proposal with his name on it. And so it's pretty clear that that's the way that this went. And so I'd say Section 12 applies.
Okay. And I just want to know what we're looking at, because when you read SB 40, it's not the best crafted piece of legislation. It has a lot of things that are somewhat vague. But so that's your gist of it. You think it's Section 12.
Yes, that's how we perceive this going as the necessary parties.
Stop. I'm sorry. Your Zoom froze up again.
Yeah, but he didn't say anything, Teresa. He didn't say anything. He was just frozen. Go ahead.
You
Go
said
ahead.
you said yes. Judge asked if you think this is Section 12 and you said yes, and then that was it that we got.
Is there anything more to add to that?
No, not to that point. I was going to address your question about necessary parties, if you can hear me.
Yeah, let me ask, and I know we're jumping around. That's just kind of the nature of this. I want to find out from Mr. Holder if he agrees what section is implicated, so we all can home in on that, and then we'll talk about necessary parties.
Sure, Your Honor. And this is the first argument raised in our motion to dismiss is I think that if any section did apply, it would be Section 12.
Okay.
But the argument that is made in our brief is that when you talk about the authority to issue an order under Section 12, the authority for entering that order comes from the local health officer, not the local health board. And so the order that we're actually talking about here was passed by the local health board, not the health officer. Although he did participate in it, he did recommend it. And so our position is that Section 12 doesn't apply. This is not a viable challenge under Senate Bill 40.
Okay. Well, let's just assume for argument's sake, Section 8 applies. How does that change the analysis? And I'll start with you, Mr. Krieghauser.
Let me pull up Section 8 here. I don't know if my internet.
Yeah, you've got a bad connection. Mr. Nye, are you available to address this?
That is
Happy
slow,
to.
Your Honor, and that's why I keep freezing it up.
Do you mind if
Yeah.
hang on, hold on. I'm going to lateral to your partner here and let him address this if that's okay with you, Mr. Krieghauser.
I'll proceed and we'll try to figure it out from there. So
Okay.
Section 8, if I'm understanding, is the section that applies to Chapter 48-932 regarding local disaster emergencies.
Right.
Okay. To be honest, we haven't looked at this deeply, specifically because of the nature of Dr. Lemaster's order, and we really have our theory as far as what we believe the facts show, as far as what type of order that is.
Well,
I
if
think-
you read the and I'm sorry to interrupt again, but I'm going to save some time here. The whereas clauses in that the county's health order specifically mentions the emergency that was declared back in 2020, and that somehow this is an extension of that. That's kind of why I'm thinking that maybe Section 8 is implicated.
If the chairperson has actually declared that same emergency as continuing.
Well,
Yeah, I'm happy to look at that. Instead of speaking out of turn, I guess what I would say is, if the court would like specific briefing on that, or for us to be prepared to address that legal issue, we're certainly willing to do that.
Well, it's almost jurisdictional, isn't it?
In as to this particular case.
Yes.
Well, again, what I would say is if we can have some time to look into that, it would be helpful to us, just so we can get our bearings.
Well, Mr. Holder, you kind of grimaced there. Are you thinking of something here about this?
No,
Section 8?
I'm admittedly far less familiar with Section 8 than Section 12, so I'm really not that deviated in camp from plaintiffs on this. If that's something that Your Honor wants to brief. In terms of the jurisdictional question, I suppose the answer to that also depends on whether Section 12 applies or not. If Section 12 applies, then that's not a dispositive jurisdictional question. But if Section 12 doesn't apply, then I suppose whether Section 8 does or doesn't is jurisdictional.
Okay, well, attached to the petition, which thankfully you obviously have to appeal the order that you're referencing in SB 40 in order for the court to make any kind of determination. It starts out with a bunch of whereases. And for the non-legally oriented, whereases are just simply predicates that say, okay, here's our history. This is what brings us here today. First thing is, whereas COVID-19 is a respiratory disease that spreads easily from person to person, et cetera, et cetera. Second one is, whereas the United States Department of Health and Human Resources declared a public emergency for COVID-19 beginning January 27, 2020, with now more than 34,722,631 cases of the illness and more than 609,853 deaths as a result of the illness across the United States. And this is the one I was referencing, whereas on March 19, 2020, the Board of County Commissioners of Johnson County issued a state of local disaster emergency declaration, which was renewed and extended on May 28, 2020, and which remains in place at the time of this order. So whether that emergency was linked to the governor's emergency, which sort of expired or whatever, this makes specific reference to the county having a state of emergency that is still in effect. I don't know what that does to anybody's analysis under either sections 8 or 12, but what Dr. Lemaster, I think it's pronounced, what he recommended, whether the board acted pursuant to that recommendation, et cetera, and what hats they were wearing at the time they did that, to me is almost immaterial to this question here, is that they're saying we're acting pursuant to an emergency. So I think that triggers a number of things, and that's the analysis I think we need to talk about. So I don't know if your motion, Mr. Holder, addresses that. Obviously, plaintiffs haven't responded yet. I'm going to be a real liberal counsel about allowing you guys to supplement your briefs, because I think we want to get this right.
Yep.
So that's issue number one. Issue number two, for relief to occur in this case, if relief can be allowed, I'm not sure the relief that is being requested is directed towards the county so much to the school district. The only reason, and this gets to the issue of whether the Blue Valley School District is an indispensable party. Because when I look at the petition, paragraph 6 talks about the petitioner being engaged in the civic activity of attending school. And I know you're using the term civic activity to be able to come within the terms of the act, but we've got a child going to school. And you reference that child's activity is inhibited and interfered with and unable to complete schoolwork, interact with friends, receive instructions from teachers, et cetera, and that the disputes over the proper wearing of masks have resulted in conflict between school officials and MMC. I mean, to get into the factual weeds of this case, if you will, that has to do with everything that's going on at the school district and zero to do with the county. And so what I'm wondering is, that's why I raised the issue. You say such enforcement activity has placed MMC in fear of imminent school discipline during the day. Then you say the school enforcement of the order, the county's order against MMC and other unmasked students is deleterious. I thought the school district already had an order in place. I may be wrong about that because we've had so many things going back and forth, but do you know, does the school district have its own separate order in place?
I think that one of the issues was how these orders, if they are in place, relate to one another. And I don't know if it would necessarily be an order versus simply a policy or a protocol, because at the end of the day, the enforcement potential under a county order issued under Section 12 or even Section 8 would be a different consideration than the enforcement under a school's general home rule powers.
Okay, so we all know from the Butler decision that I reference Article 6, Section 5, which applies to school districts. And very simply, it simply says the school districts under our Kansas Constitution have a right to manage and operate their districts. I'm not sure anybody has cited, either in your petition or not, the status of what the school district actually did. So the fact that the county, acting as a health board, said, we're directing K through 6 to do this. Let's say they directed K through 6 not to mask, okay? We think masking's bad. We think it's psychologically harmful, blah, blah, blah. What if they did that and the school district said, no, I'm not going to listen to you. We've got a separate constitutional right to manage and operate our school districts. That's why I said at the beginning of this, the intersection between the authorities of the local units of government, whether the school districts or the county commission, is bigger than simply the analysis that is it Section 8 or Section 12 of SB 40, if SB 40 even exists anymore. So Supreme Court has stayed my decision in Butler, which means we're sort of status quo. And if an attack on SB 40 and other provisions occurs in this case, I think then it's incumbent on the court to notify the Attorney General again that we have yet another controversy dealing with this legislation and the particulars by which it may be challenged. So I think there's a lot more at stake here than just simply, is it Section 8 or Section 12?
I understand. And just to clarify what I was trying to say earlier, with respect to the interplay between the county order and the school's authority to enact their own policies, I think the petition, or at least our theory, is specifically concerned with the provision in Section 2 of the county order, which says that the Board of Education for each unified school district within Johnson County and the respective governing body of each K-12 private school within Johnson County shall be responsible for enforcement of this order. And so the county is commandeering in one way or another the school districts as enforcement agents of the county order. And that is different than a recommendation. That's different than some sort of acknowledgement that the schools should use their own powers to create protocol. There's a direct order under the section that says lawful order to the school districts to enforce the county order.
But the real question then, because you have a client here, is did that order proximately cause your client's situation? Because we don't know whether the school district, look, some of these school districts may have used the county's health order for justification of their own, or they may have already arrived at that point anyhow. If Spring Hill, which straddles Johnson and Miami County, has a different approach and isn't ordering masking or whatever, that's even more problematic, because then there's a question about whether the county needs to enforce its order against that school district. But it still begs the issue as to whether or not the school district needs to be included in this as an indispensable party, because the school district may say, you know what, if the county didn't properly enact its order, whether it's Section 8 or Section 12, we still, as a school district, have a right to do what we want to do.
And I think as a petitioner, we have to peel back the layers of the onion. And if the governor had an order in place that trumped, so to speak, the local county orders, and if the county orders have an order in place that trumps, so to speak, the school boards, and basically takes out the consideration, like you said, for Spring Hill, of whether to issue mask mandates or not from the school, and puts it at the county level, the petitioner's first recourse is to address the county-wide order, and then it can appeal the child's own school board to engage in that policy discussion at an even more local level. But because the county has stepped in for the school board, this is our first place that we have to address this, because not only is it an order, but the school districts are charged with enforcing that order. So we can't even see what the difference. I don't even know if we could be able to get to a fact-finding position where we could determine the difference between a local school board policy that has no relation to the county order and an extension of the county order, and this is how they're interpreting their enforcement duties.
And all these things that you raise point up the fact that when the legislature said a judge has to make a decision within 7 days with this kind of complicated situation, merely underscores the fact that judges need to have time with input from both counsel and briefing to discuss these things, research these things, and come up with the right answer. And that's one of the reasons I struck down that provision in the Butler case, because the judiciary has a completely separate role here to try to get it right. And if we're under the gun to hurry up and make a decision that may be wrong, that implicates the judiciary and people's confidence in the judiciary's role in that. So I get you're all on board with us getting this properly briefed, researched, and then coming up with some solution, even if it takes more than 7 days.
Yes.
Mr. Holder?
Well, I want to make sure I understand. Yeah, in terms of the dispositive briefing, yeah, I think that's absolutely the case. In terms of the mandatory requirement that after a fact-finding hearing happens, that a decision has to be then put in some place, I think that is a mandatory requirement under the statute. But in terms of the briefing that happens before the fact-finding hearing, yeah, I'm completely on board that is, based on the factors we've outlined all morning, that's something that needs to have a lot of time and effort put into it before any kind of hearing is even booked.
Okay, well, whether there's fact finding and whether it takes longer than 7 days, that still implicates the judiciary's role. So my thought is for this status conference, we come up with a briefing schedule, get these things outlined and go from there. I need to have counsel for the plaintiff reveal to me the name of the parent so I understand who the parent is in this case. I don't care if you do it privately through a letter or whatever, but I also want defense counsel to be aware of that so they know. Do you know who the parent is so you're able to research the situation, Mr. Holder?
I don't know definitively, no, Your Honor.
Okay, because I think we need to know the exact circumstances at Blue Valley School District. And while we don't need the child's name emblazoned in any lawsuit, we need to know who the parent is so So that can be, if we have to get to fact finding, we'll know exactly what needs to occur at that stage. So send me a letter and I'll put it in my personal file, but I do require that you actually identify your client.
We will do that and we'll share it with council.
Thank you. Okay, any other suggestions that we need to talk about?
I don't believe-
I suppose.
Start with
I'm-
plaintiff's
I'm-
counsel.
I don't believe so. I think we're on track for starting to get towards your issues as well as addressing the motion to dismiss filed by defendant. I don't know if we want a deadline for that or if we can certainly get that on file today or if.
Well, can you two talk? I mean, if we had a case management conference, which is this kind of savors of, can you guys talk as counsel about what you both can do and make sure you both have your needs met? And honestly, if you think you need to expand the briefing or the motion, Mr. Holder, to incorporate some of the issues here, I'm not suggesting you because I've not seen it, then obviously the plaintiff's response to that would be held in abeyance until that actually occurs. So I'm not sure where things are. I will ask, Mr. Holder, you were at the Fisher Patterson firm, is that correct?
That's correct, Your Honor.
Are you going to be involved in the new lawsuit 21CV4112?
I can't answer that at this point, Your Honor. I know you mentioned at the outset of this that you were assuming that we're all had information about that. I don't. So,
okay. Well, that's a lawsuit that's got 20 plaintiffs, named plaintiffs, and I think Mr. Protzman's filed it. And again, it's against the county's order, the same order. And so I'm wondering too, if we're going to have two lawsuits going over the same order, I'm wondering whether or not, obviously this case has raised that issue. There may be some additional efforts in that regard. So I don't know, but I just think you guys need to be aware of it, because one thing the county doesn't want to have as a defendant is conflicting orders and multiple attorneys going after the same thing with their different fact wrinkles or clients. So, I throw that out there.
Sure. Conceptually, I think that there are mechanisms in place under the rules that would allow joinder if we're talking about the same thing. Like I said, having not seen anything about the lawsuit, I can't say whether procedurally that makes sense or not. I mean, in theory, it seems like it would.
Well, I'm not suggesting that has to happen. I'm just saying that there's more stuff out there. Same defendant, same judicial district, et cetera. So, okay.
Understood.
Well, what I'll do is please send whatever briefing that you do in addition to when you file it with the clerk's office. Email your briefs in Word to Ms. Schrader, so I can work on that and get working on it and try to get something pulled together. If I'm gathering we're going to do something in two stages here. The first stage will be the legal issues, kind of where we stand. Does the motion to dismiss raise issues that require whatever? And then secondarily, the evidentiary issues. If the case isn't sustained on the motion to dismiss, does that militate some other action? And meanwhile, I'm guessing we'll probably have a decision out of the Kansas Supreme Court here by, I'm assuming in October, maybe, I don't know. But if the briefing from the Shawnee Mission School District was supposed to be filed yesterday, and then the reply brief, the Attorney General is supposed to be filed on the 16th, that will close up all briefing, and I'm assuming oral argument will occur. And in the last case, if you look on the Supreme Court's website, Kelly versus LL or the Legislative Coordinating Committee, that case was argued the same day the opinion came out, which is pretty remarkable. But obviously, all the briefing and I'm sure internal research by the court allowed them to come up with a swift decision because it was necessary. So I'm assuming something like that might occur in this case. So we've got all that in the background. Okay, anything else, guys?
Your Honor, just as far as
Go ahead, Ryan.
As far as the verified petition, one of the reasons why we wanted to talk to the court before submitting that is because of the identity. Is it okay with the court if we have our client verify the petition at the same time we send you the letter, Your Honor?
Yes.
Okay. We will do that, and then we will get with opposing counsel and come up with a suggested briefing schedule for the court, and we'll submit it to Your Honor.
Does this sound good to you, Mr. Holder?
That sounds great, Your Honor.
Okay. Looks like we're on board, and I wish you both the best weekend.
Thank you, Judge.
Okay, guys, we'll see you.
Yep.
Thank you, Judge.